Chaim Saiman, who's joining us from Villanova, where he is professor of Jewish law and a well-regarded and well-known insurance law scholar. The usual story applies here, which is he's got 40 minutes or so to give his talk. Chaim, do you want to take questions, clarifying questions in the middle, or do you want to hold them to the end? Or
I'll hold to the end.
Great. So that's the deal. And when you have a question, please feel free to raise your hand or chat it to me in the WebEx. Before we turn it over to Chaim, Travis, did you have anything to add?
So just quickly, so we are going to be announcing the lineup for the spring semester soon. And if you want to know what exact dates we're reserving for those sessions, in the email that you got announcing this session, there's a little link to a subscribe that allow you to subscribe your calendar to our calendar, our events feed. And I would encourage you to do that. It'll block time off in your calendar henceforth, and it'll make it easy to prevent double booking. But anyway, we look forward for that announcement, and we are excited to see you in those sessions in January.
Great. All right, Chaim, the floor is yours. Thank you so much for coming.
Okay, thank you very much, and it's an honor to be invited and to see and talk a little bit about insurance with you. As you all know, law professors, the number of opportunities to nerd out on insurance are limited. So I greatly appreciate it. So I want to present an article that I published earlier this year, titled in the Maryland Law Review, "Is Insurance Just a Contract or a Just Contract?" And basically, to set it out, there's different rhetorics. There we go. That one reads in insurance cases. So I just threw up a bunch here that we've all seen variations of, and these are all very recent. Insurance policies are contract. Delaware courts apply ordinary principles of contract interpretation, right? That's Delaware. Nevada Supreme Court, legal principles applicable to contracts generally are applicable to insurance policies. South Carolina. Insurance policy is a contract between the insured and the insurance company. The policy's terms are to be construed according to the law of contracts. And then Utah, an insurance policy is merely a contract between the insured and the insurer, and is construed pursuant to the same rules applied in ordinary contracts. So we get a lot of this language that's sort of just telling us nothing special here. It's just contract law. I always tell my students, if this was true, we wouldn't have a course. You already took it in contracts. There's nothing to do here. So on the one hand, there's this tremendous protestation that there's nothing special or insurance, or in the terminology I adopted, it's just a contract. But so what does that mean? Part of what I want to get to is kind of what does that mean to say it's just a contract? And I think what that means is that, there's no normative edge. When we think of contract law and the way these courts are discussing it, a contract is just a vessel, a vehicle for capturing and enforcing the party's intention and intents, and it doesn't have any normative content nor any assumptions about what should or shouldn't be in the contract, what it should say. There's no ideal type of contract. A contract is merely an empty vessel whose job it is to take the party's intentions and to then create a legally enforceable document or set of relationships through that. And this is sometimes called the Willistonian conception of contracts. And it's, of course, connected to plain language and four corners, which is if it's in there, it's part of the contract. If it's not in there, it's not. Contract itself is basically an empty shell. It doesn't mean anything. The just a contract view is also supported by a narrative about why that should be. And this is a mixture of what I'd call general freedom of contract arguments that exist throughout the law over, right? The efficiency arguments, the autonomy arguments, and then that's kind of connected to some insurance specific arguments that, well, look, insurance is about taking in premiums and paying out claims, and they've got to be correlated. Right? If we start throwing in things other than what the insurer understands to be undertaking, that's going to get out of whack. If we expand coverage too much, certainly by law, we're going to make insurance too expensive, and that's either going to lead to it being too expensive for people to buy, or the other way, insure insolvency. But none of those things help the customers or the insurers. And finally, this pushback of this idea that, well, insurance is always standard form and it's take it or leave it. And the insurance industry responds, see, we've got a gajillion different endorsements that can kind of modify or correct coverage in thousands of ways. And therefore, I mean, yes, these are all off the shelf, but you can customize your insurance pretty well if you want to. And therefore, we should just sort of end this sort of contract of adhesion language that's so pervasive in insurance law. And therefore, where one comes here is that insurance contract interpretation is at least, or not, if not more, formalist and plain meaning than general contract law. And that I call the insurance is just a contract narrative. And all those courts we saw at the beginning sort of protesting that it's just an ordinary contract, this is what they mean, nothing special. Now, there's a counter sort of canon, which I would call that insurance is a just contract in the sense of justice, right? That it's trying to do something else. There's unique features of insurance relationship and insurance law that require a different type of arrangement, and we can't just collapse it into contract law. And this too, right, has its sort of canon of cases. They're a little bit different. We'll probably talk about that. So, right, Hawaii, there's a special relationship between the insurer and the insured is atypical, because of the adhesionary features, which further justify the availability of a tort recovery. Colorado, insurance contracts are unlike ordinary bilateral contracts. Arizona, the special nature of an insurance contract has been recognized by courts and legislators. Pennsylvania in the 70s, right? Insurance contract is not a negotiated agreement. Rather, conditions are by and large dictated by the insurance company. And then my former colleague Jack Dobbin, in his in the opening page of the West, nutshell on insurance law, basically starts that when you read insurance cases, it's like reading a chapter out of Alice in Wonderland, because insurance is a world unto itself, consisting of a minefield full of hidden traps to those who expect words in a contract we apply to their usual meanings. So this is a sort of counter canon of cases, that insurance is special or it's a just contract. And this too has a sort of justificatory narrative, right? And this has to do, we all know this, right? Contracts of adhesion, information asymmetries. Insurance is aleatory, right? So 90% of the time, or a very high percentage of the time, the insurance company doesn't do anything, right? Most of the time it just collects money. But then when something happens, it's got to step in. From a contract perspective, there's no ability to test the performance, right? Because once the loss has happened, you're done. There's no insurance is available. There's no ability of post-breach mitigation or post-breach, sort of substitute performance. The way I always start the class to my students is insurance is one of the few things that you buy and hope to never use. And therefore, when you need it, you shouldn't have to fight the company for coverage. And then, quoting here Tom Baker's ideas, carriers promise security, certainty, and peace of mind, yet sometimes deliver cold adherence to dense policy language, and it's the law's job to prevent that. So that is the narrative. So which is it, right? Is insurance just a contract, or is it a just contract? And my sense is, and really the sort of point of this paper is to say this, while there is just a lot of noise and contradictory talk, there is an intelligibility principle here. And that if we look at it, is that these doctrines are not distributed equally or randomly around the insurance canon, but they kind of cluster. And the way I like to think about it is that they cluster whether we're looking for at the scope of the breadth of coverage, in other words, how wide, how many things are covered, or the depth of coverage, which you might think of the incidences of coverage, or the rights that obtain when there's coverage. And the basic point that I'd like to sort of stress to you over the next little bit is that the kind of contractarian, it's just a contract, that gains an upper hand when we're asking, is this loss within the bounds of the policy? Whereas when we go to, okay, you are an insured, or at least potentially insured for this loss, what are your rights? That is where courts seem to be attracted to it's a just contract paradigm, to the sort of counter canon of insurance is special, where they have a thicker normative view of what insurance is, what it should be, rather than merely the language in the policy. And what I like to say is that there's a logic here, right? It's not random, because if we think of the problem of expanding coverage, it's the unpredictability of what will be covered, and then the unpredictability of how much risk it's undertaken. And what I think is that is highest when we look at scope, at breadth, right? Because including a new category of risk, especially one that's unanticipated and one that's difficult to predict and one that's difficult to price, is what sets the sort of insurance relationship out of whack and insurance economics out of whack. By contrast, usually the cost of deeper insurance is easier to predict, and it's derivative of costs already assumed in the policy. And therefore, courts are going to be attracted to this thicker view of creating or normatively thicker view of creating a just contract, because that price is easier to figure out and can be baked back into the premium and then distributed in the way insurance companies do. So basically, there's a deep, broad distinction, and that distinction reflects, at least to a degree, heuristically, a sort of view of what is going to create new liabilities that are sort of totally unforeseen, and what are kind of more repetitive, routine sorts of things that are can be expected and can be baked into the policy price. So to tell this story, I want to start with what I call the fall of plain meaning, because if one looks, in early insurance law, let's say from the beginning of the 1900s to the 50s, it tends to be pretty plain languagey. And then in the middle decades of the 20th century, probably Robert Keaton is the key figure here. It changes and begins doing things that are different, probably easiest captured under the doctrine of reasonable expectation of the insured. Now, as I always tell my students, liability insurance works really well when it starts with something that goes boom, because that's really how the policy is designed. And as soon as the injury or the accident or whatever it is, the occurrence, I guess we should say, is not something that goes boom, insurance gets pretty complicated. And the sort of classic case of this is came up in the asbestos litigations that were hot in the 70s, 80s, and to some degree still. And the way I tell it to my students, to simplify it, you imagine like a 10-year window in which in the initial years someone's perhaps exposed to asbestos, then maybe they take it away and they develop some but the disease is growing inside their body, and then it can be seen in medical imaging, and then they develop symptoms, and then they feel quite sick. And if you take that basic paradigm, you've got a bunch of questions that are not addressed in the plain language of the policies, certainly as they existed then. So the first one is, when does the bodily injury take place? When one first inhales the asbestos, when one continues to inhale the asbestos, when you could see it on imaging, when they start feeling bad, when they're sick. The second question one would ask is, how do we conceptualize this harm of the mesothelioma or the sort of sickness that one gets from the asbestos? Can that be subdivided into different years, or is that just an indivisible harm? And then if we think of multiple years and multiple policies and multiple layers of insurance, so how do we conceptualize each insurer's liability over the whole period, given the amount of the risk that they underwrote? And a famous case in the 80s, which is sort of, I think, typical of cases in that era, Keene, I'm talking about the DC Circuit case, basically answered each one of these questions in a pro-coverage manner. And what that does is, so now you have successive policy years easily tapping their limits, right? We just think of the way an insurance policy is conceptualized, say, well, okay, the chance of a total loss, a house burning down, it's going to happen, and it'll happen to somebody one year. But almost by definition, it's not going to happen the second year and the third year and the fourth year, right? And that's the way insurance economics are thought of, that these are largely freak accidents. And all of a sudden, what these interpretations said, that going all the way back to the earliest possible exposure to asbestos and all the way to the end, to either the end of the person's life or the end of the insurance coverage, each one of those policies is triggered. So now you can have 20, 30 years potentially of at limits calling on a policy. That totally puts the sort of insurance economics out of whack. And therefore, these interpretations created billions of dollars of unanticipated liabilities, not reflected on any policy language, but on a court's kind of normative understanding. And if you look at these cases, they talk about, well, the purpose of indemnity, the principles of insurance, the reasonable expectations. These are the legitimating and justifying factors, much more than any concrete language. And that spate of interpretation then creates a huge backlash. And that backlash is, no. we got to go back to plain meaning, right? We're not going to do any of this kind of mushy, fuzzy principles of insurance ideas, but plain language. And therefore, what happens is that the doctrine of reasonable expectations, which starts its career as a very pro-coverage idea, winds up being reinforcing the plain language, because courts will say, well, it's not reasonable to expect coverage outside of the plain language, which is like a great 180 of this doctrine. And that's sort of in the 80s, 90s, 2000s, it begins to go into that move, such that by the time the restatement of liability insurance is issued a few years ago in 2019, the version that passed actually is more plain languagey than the restatement of contracts, right? So where the restatement of contracts has a more contextual approach and is more open to extrinsic evidence, by the time you're at the restatement, insurance is now not just like an ordinary contract, but more contracty than contract. So that is the story of plain meaning. And that is, I would say, where we're going to get and why we get all this language of ordinary contract law, plain meaning, plain language, nothing special insurance. All right. And the reason, as I said, is because here the experience was that these doctrines were used to broaden coverage in such a way that set the sort of the relation between premiums and payouts out of whack. And therefore, this was the corrective. Now I want to go to a bunch of doctrines where the opposite is true, where it's not just a contract, but there's some judicial impulse to create a just contract, where the rules are quite different than contract law and at odds with sort of a plain meaning approach. So if we think about the notice prejudice rule, so the notice prejudice rule, when we say it that way, is an insurance-specific rule, but it's a version, it's an insurance version of a doctrine that we teach in general contract law called the doctrine of disproportionate forfeiture, right? The famous case about this that every lawyer probably remembers from law school is Jacob and Young versus Kent, the famous Cardoza case with the wrong pipes. If you don't remember the name, you remember the pipes that were the wrong brand. And basically, the contract called for brand A of pipe. The builder winds up putting in brand B of pipe, and therefore, the homeowner says, I don't have to make the last progress payment, basically, or I get a huge discount off my house because, it's what the builder owes is the cost of ripping out the old pipe and putting in the new pipe, which would be a lot. And what Cardoza basically says, and this is the way the restatement of contracts interprets it, is that there's a doctrine of disproportionate forfeiture. Was the condition breached? Yes. But we have to balance how much harm to the homeowner, in this case, very little, right? How much harm to the builder, in this case, a lot, the cost of ripping it out. And we're going to say, listen, we're not always gonna sort of go with the straight reading condition. But if you can show that there's a disproportion, we will sort of waive the condition. But this doctrine in contract law has two important features. It's at the discretion of the court, and it's the breaching party, in this case, like the builder, who bears the burden of proof to show that the forfeiture outweighs the harm to the other party. Now, in insurance law, we have the insurance law version of this is known as the notice prejudice rule, right? And this comes up when there's a timing condition, right? Typically, right, the insurance policies say you have to immediately let us know that there's been a loss, a covered loss, and forward us all the paperwork and things like that. And every now and again, insurers will not do that. But as applies to insurance, right, it applies as a matter of law, unless the insurance company can show prejudice. So we flip the burden of proof, right? It's now on the non-breaching party, who's the insurer, to show prejudice. And it's not typically at the discretion of the court, but applies as a matter of law. And this came up in a Supreme Court case in an ERISA context, where for ERISA preemption reasons we'll go into, the Supreme Court had to decide whether California's notice prejudice rule is a special rule of insurance, in which case it would not be preempted by ERISA, or a general rule of contract law, in which case it would be preempted by ERISA, and it ruled that it's a special rule of insurance. Now, in one case, in the Tennessee case where they adopted such a rule, they say, well, we used to hold of the general contract rule, but we're gonna adopt the insurance specific rule. And they basically give three reasons, kind of classic, what I would call the insurance counter-contract narrative. They say the adhesive nature of insurance contracts, the public policy objective in compensating tort victims, and the inequity of insurer receiving a windfall due to technicality. Pennsylvania court said that the strict contractual approach is based on the view that insurance policies are private contract in the traditional sense, a view that is no longer persuasive. So in other words, to defend this, courts go right to the classic aspects of the insurance counter candidate. Now, Tennessee is interesting because as part of the dust up over the restatement of liability insurance, they passed the law that Tennessee a state statute that Tennessee applies ordinary contract rules to insurance contracts. But I don't think anybody thought that when they said that they are overruling this Tennessee Supreme Court case, even though if you actually took that seriously, that's what they would have to do. Now, I think notice prejudice is a great example of deeper rather than broader insurance. In other words, it only arises once the claim is already covered within the bounds of the policy. And what it does is it allocates the risk of late notice to the insurer, capped at the amount that would materially harm the insurer's interest. So however one calculates that, right, at some point, if it causes material harm, the rule doesn't apply. But shy of that, it applies, and it allocates that to the insurer. But you'll notice that it doesn't create a new class of liability. And from an insurance company's perspective, it is not so hard to say, okay, given that we cover, our scope of coverage is X, it's X plus, right, the number of insureds who will provide late notice at a, non-material harm level. And sort of within the context, that's not an impossible number. That doesn't expand liability throughout. And therefore, I think what courts are doing is we're willing to kind of give that deeper, slightly more expensive insurance and bake it in to the policy and the premiums because its net impact is not huge. I'll do maybe another example. I don't want to go through all of them in the paper, but maybe we'll do another one or two more before we kind of wind it down. So another example is good and bad faith. So if we think in contract law, general contract law, so starting in the 50s or so, comes in through the UCC and the restatement second contract, we see the idea of good faith in American contract law sort of begins to flower. And liability for bad faith starts developing across the law, or at least in other areas, so that insurance is not exceptional. So it shows up in franchise agreements, and shows up in employment agreements, shows up in a lot of places where a bad faith breach will lead to enhanced damages. And then starting around the 80s, the law and economics folks, so Posner, Easterbrook, Scalia, when he's still in the DC circuit, really lead a very direct and I would say successful assault on the concept of implied terms and substance of good faith in contract law. And basically, in a million different ways, say, look, there's no independent duty of good faith that can be breached. It's merely the terms in the contract that if there's an obligation, perhaps they have to undertake it in some good faith. And this, it becomes very influential and changes doctrine. So in the 90s, the UCC is amended to expressly make this point, saying that no independent cause of action for failure to perform in good faith, and that an implied clause cannot be independently breached. And many state Supreme Courts sort of do the same thing, and they basically say, good faith does not establish new independent rights or duties beyond the contract. So basically, good faith is I guess one would say, killed or stillborn or whatnot, and it's very difficult to get a cause of action in contract on good faith. Now, when we come to insurance, and I want to focus here specifically on first-party bad faith, because that's the one that's most similar to ordinary contracts. The standards differ from state to state, but certainly there's this idea that a willful breach leads to enhanced damages, either because there's another tort of bad faith breach, or the way the law is willing to consider what we call emotional damages, sort of the pain and suffering damages, so to speak, for breach of the insurance contract. Now, there's not a shred of word of this in the policy, and it really does act as an independent cause of action. When we think of remedies, so typically in contract law, particularly a contract to pay money, which is what an insurance contract is. So if I have a contract with you that I'm supposed to make an investment in your business on a certain day and I don't, or I'm supposed to repay the loan on a certain day and I don't, or whatever, the remedy is is simply the cost of borrowing that money at the market, right? Because the law's assumption is, and this was true of insurance law in the sort of certainly in the 19th century, early 20th century, that the remedy is limited to the cost of borrowing those funds. And the idea is you can always borrow on the market. When it comes to, however, in insurance, the cases generally waive that and say, no, the sort of harm is presumed and we don't require mitigation. Same thing with attorney's fees. A non-breaching party still has to pay their attorney's fees, whereas on cases of insurance bad faith, at least in certain states, insured can collect fees from enforcement. So these are rules that do not apply to ordinary contracts. Again, what we think of as a just contract or insurance law exceptionalism. And the justifications for this are sort of rolled again all into that, that kind of counter narrative. So this is from the Alaska and the Arizona Supreme Court. They quote each other. An insurance policy is not obtained for commercial advantage. It is obtained as a protection against a calamity. In securing a reasonable expectation of the insured under the insurance policy, there's usually an unequal bargaining position between the insured and the insurance company. Often the insured is in an especially vulnerable economic position when such a casualty loss occurs. The whole purpose of insurance is defeated if an insurance company can refuse or fail without justification to pay a valid claim. In other words, right, this is a deeply normative view of what insurance is, right? It is these things, and therefore we have to interpret the policy in light of what insurance actually is. Right, and there, but now here again, I'd say that bad faith is probably broader insurance, but is deeper insurance, right? The enhanced liabilities correspond to cases most of the time where the policy already covers a loss. And in any event, the triggering events are within the insurer's control. First party bad faith is typically some version of dilatory claims handling practices. These are events the insurer controls and therefore the pricing which is in his hand rather than sort of being subject to these external forces, right? It's essentially insurance for insurer malpractice and doesn't expand the scope of coverage and therefore can easily be priced into the policy. And I think because of that price structure, courts are willing to sort of bake this in, even at the fact that it surely does increase the cost of insurance because the costs are relatively known, they're not so hard to figure out, and we're going to therefore rely on the counter canon to give deeper insurance. I'll do one more doctrine because I do want to wind up and leave time for questions. And there's a bunch of doctrines that I call insurance statuses. I'll list what they are, but we'll only maybe do one of them. By insurance status, I mean as follows. So what's, if we go all the way back to Henry Maine, from status to contract, the way he explains it, and I think it's very helpful here, is that both of them are sort of voluntary undertakings, right? One chooses usually to enter a status, just like one chooses to enter a contract. The difference is that when we say status, once you walk in, everything's sort of preset, right? It's like you walk in a room and you can't move around the furniture very much. The bed's here, the table's here, the windows are here. You could choose to enter the room or not, but once you enter the room, you are in a status, and either you can't move it at all, or it's very difficult to. So either the individual bits of that status are not at all customizable, or only customizable at great sort of difficulty or great demonstration of intent. As opposed to a contract where you walk in, it's basically an empty room, and you can design it however you want. I think there's a bunch of areas that are best understood as once you're deemed an insured, you have a status. And therefore, it's going to be difficult for the court, for the insurer to muck around with it unless it really sells you an entirely different product, which happens. So I'll take a simple example, which is the make whole rule as applies to subrogation. So to quickly review, a very easy case would be if I get into an auto accident and I then get, $200,000 from my first party, my own insurer. And then, I later sue the driver and get, let's say, $400,000 from that driver's insurance company. So can my insurer say, hey, look, we already paid you $200,000, give us that back, right? And that's called subrogation. And almost all the standard insurance policies, auto, home, and everything above that have some version of this policy. Now, Courts, however, have interpreted this in a very, very limited way. They've imported this idea of the make whole rule, even though this has no basis in the plain meaning or the text of the policy. And what the make whole rule basically says is, in order for, in this case, the first party insurer to be able to kind of recover some of that money, I would have to be made whole and basically not suffer any loss because of that. But if we add these two recoveries together, and I'm still somewhat lacking, I'm still worse off than I was at the beginning, I'm not considered made whole, and the subrogation right doesn't attach. And courts have a very capacious understanding of what make whole is, right? So for example, if I had to pay a third of that to my plaintiff's lawyer, which is very commonly going to happen, they're going to say, well, you weren't made whole, right? It will include things like the spousal claims and all sorts of things. So at the end of the day, this doctrine doesn't, the subrogation clauses don't do a whole lot of work because of the way the courts have interpreted them. You can read these clauses from here to tomorrow. You will find none of this. Now, it's true that you can sell, an insurer can sell what's called a first dollar policy, right? That's written very differently, right? And therefore says very clearly, no, the first dollar that comes in, the original insurer can get. But that's really a different thing. That's why I think this is like a status. In other words, if you're in a typical policy, you get the make whole rule, sort of, even though it has not even a shred of relevance to the policy language. And it's customizable only in the sense I can send you a different product. Another example of this, which we won't go into, is the duty to defend, right? Once there's a duty to defend, courts have given that a structure in a meaning and have resisted insurer efforts to kind of tinker around with it. Sure, an insurer can sell a policy that doesn't have a duty to defend, or a defense cost reimbursement policy, right, which also doesn't have it but basically pays for it. That's a different animal. But once you're in duty to defend land, it's basically pretty rigid. And I think, again, the logic here is that these are statuses, and that once you've obtained the status of the insurer, it's what the courts are going to do is use this sort of a counter contract or just contract narrative to reinforce the idea that that goes deeper than the plain meaning. Why? Because typically it's expanding within coverages that are already there, rather than like we saw with the cases earlier, the King case, where it's sort of covering whole new territory. Okay, so if you're paying attention, you should be asking, well, what about contra preferentum? Right? Contra preferentum seems to fit some, but not all these criteria. It fits these criteria in that the insurance version of contra preferentum is different than the contract law version of contra preferentum. Contract law version of contra preferentum is a tool of last resort, and because basically anything defeats contra preferentum, you don't come onto it very often. And we have, case law in the non-insurance context, both in America and in England, basically saying this doctrine doesn't do a ton of work. By contrast, right, Ken Abraham famously said that contra preferentum is the first principle of insurance law and does insurance everywhere and sort of applies everywhere insurance. So it fits the fact that there's a contract law version which is at odds with the insurance law version. Though here, you will correctly say that doesn't contra preferentum often broaden coverage? And I think that the answer is certainly sometimes it does. So how does that fit into the thesis? So what I would say is it's certainly the hardest fit, but I also think that the thesis might help us towards better applications of contra preferentum. Every scholar, every observer who's written in contra preferentum comes to whether they are, have a reputation of being very pro-insured or very pro-insurer, all comes to the, insurance company, all come to the same conclusion that contra preferentum doctrine is a mess, because basically if a court decides that it's ambiguous, then it goes one way, and if it doesn't, then it goes another way, and there's not great standards to determine it. So I think that here we can sort of use this heuristic that's been developed that shows up in other cases and say this ought to be at least a factor to consider, is that if the contra preferentum reading kind of really takes it to a new category of risk that is not sort of otherwise assumed in the policy, so then it should probably be rejected. But if it offers what's effectively a deeper type of coverage to things that are otherwise within the bounds of the policy, perhaps this is a place to do it. And in the paper, and I'll sort of end here, I offer two relatively recent cyber insurance cases where I think you can see the difference. So in one case called Portal Health, this is a coverage B claim, where what happened is the company that was basically in charge of keeping the data of the health systems, it put it online in a way that if you Googled your name, you would then find your medical records or some aspect of your medical records, right? So basically, it didn't have that gate keeping it locked in from the general internet. And they were sued by people, I guess, who Google themselves. And the question was, well, was this an electronic publication of the material within coverage B? And the court said, well, we know that online, that's not the problem, but did they publish it, right? Because publish usually has a kind of push out there. As opposed to this, which is kind of, sort of hard to figure out how to classify this. And here the court used contra preferentum and said, yes, this is covered. And I think this is a good use of contra preferentum because coverage B covers both intentional and unintentional publications. So the idea of an unintentional publication is already within the sort of bounds and conception of the policy. And therefore, this is a good way in place to use contra preferentum. I contrast this with another case by the Indiana Supreme Court called G&G Oil, where this was a different kind of policy, basically a fidelity policy that covered losses caused, when a computer was used to fraudulently cause a transfer. And what happened here was that they were hacked by hackers, and they were locked out of their computer system, and they had to pay a Bitcoin ransom. And they paid the Bitcoin ransom, and then they wanted to get that loss of the ransom payment recovered. And the court, I think, incorrectly expanded this and said, well, they said fraud can mean lots of things. And here the fraud was that how they initially get to your system is they sent you an email saying, that got someone in the company to click, and that was the fraud. And then there was a transfer because they used computers to transfer the Bitcoin. And to me, that's wrong because now we're really taking on a different type of coverage than is conceptualized in the policy, and for which there are other policies, right? This is about someone kind of making a mistake to transfer money. Not here, where they knew they were transferring the Bitcoin. They knew they were doing this. They were doing this on purpose, and that the fraud was that they got into the computer. I think, so again, not every cases are going to be so easy, but I think this is an example of, if we use our sort of deeper versus broader coverage as applies to contra preferentum, it might kind of do some work in figuring out when the right and wrong times to expand those are. So I think the main takeaway is really just to make sense of when insurance law hews to this plain language, neutral interpretation rhetoric, and when it is tilted unabashedly towards insured and coverage. And because in briefs and practice, one will always be hit by an avalanche of these cliches, depending on which side of the insurer will always basically send some version of the "it's just a contract" cliche, and the insured looking for coverage will always send some version of the "hey, insurance is special" cliche. I think just having a mental map of when we should kind of pay more attention to this is a good idea. And then lastly, possibly in a few places, some others I go in the paper, it can help kind of guide both contra preferentum and maybe some other doctrines here and there that kind of veer off this line, and that this is at least a good place to start. So with that, I'll end. I will cease sharing the screen so I can see everybody, and happy to engage and take questions.
Wonderful, thank you so much. So please jump into the queue if you would like to ask a question. I know there were students who read the paper who had interesting things to say, but I don't want to put anybody on the spot. So anybody want to come in? Travis, you got something? Larry, all right, please.
Yeah.
Your video's off.
Oh, is the video off?
Yeah, I know you're on. You're on.
Okay, good. Yeah. So going back to the asbestos issues, it seems like in reading those, it wasn't like the court was just creating new expansions. They were trying their best to determine what the terms all sums mean, what bodily injury means. So it seems like they're still looking at the language of the policy and doing the best they can to figure out the dispute. So I guess the question is, I mean, are you seeing, or are you arguing that the just contract principles are kind of divorced from the plain meaning and other basic contract principles? Are they really in conflict?
I want to make sure I understand the question. So,
Yeah.
I'm talking just to back. I'm talking about the Keene case specifically, which relied quite heavily on these sort of like it had a mental image of what insurance should be,
Uh-huh.
and it kind of used that as a tool to interpret all those clauses in the way that they did. Obviously, there were tons of cases, and they don't all go the same way. But I do think that my own sense is like this backlash or this insistence, and just keep on hammering up insurance is not special, is a reaction to that type of analysis, right? There are other cases, obviously, and things like that. So I'm not sure that
Yeah.
that's kind of part one. So is that responsive?
Yeah, it seems like I'm trying to in my mind figure out if there is any conflict, because there's always going to be just contract principles. Is there assent? Was there consideration? I mean, there's basic contract principles in every insurance policy, but then you
Sure.
get these layers that we talked about with bad faith and contrapreventive, et cetera. So to me, it's more like not a conflict, but just more of an enhancement or a natural evolution based on the public policy attributes of insurance.
Right, but if you take all those statements I put up at the beginning seriously,
Yeah.
then none of those other things should exist, right? Because if it's just a contract, we should not have extra special insurance law. But of course, we do have extra special insurance law. What I'm trying to do is figure out, well, when do we have extra special insurance law and when do we not? Because part of the thing about the interpretation, and there are people here on the call who fought the ROI fight, blow by blow, is that it winds up in some strange way. Insurance contract interpretation is more plain meaning, at least if you take the restatement, than general contract law. So like what happened here? So that's really, I'm just trying to explain and account for it.
All right, thank you.
Great. So I have Travis in the queue and then Aisha after that.
So I love this paper and this project, especially because it cuts to this question of whether insurance is special, whether insurance law ought to be regarded as a field. And obviously, I'm biased in favor of the,
We
the
did our
yes
best.
answer to that question. But anyway, I think that a lot of people, who join these sessions share an intuition that there's something distinct about it, really worth exploring. And I think that this paper does a really excellent job of setting up the kind of like the explanandum, like the weirdness of insurance law as compared to traditional contract. And I'm less clear on what the answer to that, what the explanans is, what is it about insurance law that invites this type of just contract analysis that I don't know that is absent in other types of contracts? Why does insurance law draw this type of judicial perspective in a way that other contracts that also involve risk shifting or that also involved adhesive relationships don't? I mean, we have the restatement of the law of consumer contracts, and maybe there's some similarities there, but structurally, what is it about insurance, you think, that invites this sort of this weirdness, which I think you've done an exquisite job of explaining and synthesizing at least a big part of?
Sure, thank you. I appreciate that. So I think it's a few things, and you're certainly right. And in my own mind, in writing, I was writing almost with the restatement of consumer contracts in the back of my head, which is to say, most of these sort of doctrines do not appear there. So I think that the what they call the aleatory nature, or the way I'd say it's a product you buy and hope to never use, has a lot, right? So most other kind of you're buying a thing, right, or a service in which you can test whether you like it or not, right? So think of all those examples that the restatement of consumer contracts sort of drills on, right? So these are either physical goods or services, in which case at some point whether your phone company is doing what are the calls dropped or not, right? Does the computer work or not? Is the credit card charging or not? Whatever it is, right? So there's opportunity for test, in which insurance, right, there isn't. By the time you're testing it, it's too late. I think that is sort of one of the special parts, right, which we call the aleatory nature. Right, even in other financial services contracts, you're typically getting some response from the other system. I think the other answer has to do with the third party context and some bleed into the first party, right? In other words, liability insurance really is different. Right now, how much of that is justified in contract terms or not contract terms, you can argue, but now you're getting into things that are more similar to places like medical malpractice, attorney-client, various professional malpractices where sort of like notwithstanding the contract, the law is going to assert certain liabilities, right? And I think that one way to think of the liability insurance relationships is to think of it as a form of kind of professional malpractice sort of thing. It's not quite that, but it's in that zone. And then some of these things bleed, and you could argue, and people do, whether that bleed is appropriate or not. So I think those are the two main factors, as I would see them, that are unique to insurance as opposed to your other places where people tend to get very hesitant about boilerplate and asymmetries, et cetera, et cetera, et cetera.
Great. So I have the queue as Aisha, Jay, and Walters in there. Go ahead, Aisha.
Hi, thank you. So I'm one of the students, the insurance law students here at UConn Law, and I got a response from Professor Siegelman that told me I may have totally misunderstood a very large part of your article. And so I wanted to ask you to clarify it because we didn't have time to discuss before class. But in your article, it seems like you're exploring how insurance law kind of adheres to but deviates from general contract law principles. Especially when you discuss like reasonable expectations and the notice prejudice rule. So in my initial interpretation, I thought you were basically juxtaposing insurance law and contract law and basically showing that they're fundamentally different and like how they should be interpreted. But I'm wondering if you were actually saying that like insurance law kind of builds on and extends or expands contract law, as opposed to kind of contrasting the two. Could you just, sorry.
So maybe the answer is a little of both, right? But given the way contract law has gone, so one way to describe it, let's take the way you said it. One way to describe all these things is that it builds on principles that are kind of, on the 2 volume setting in contract law, and it puts them up to the 8 or 9 volume setting in insurance law. The reason but it's also contrast, is that a lot of contract law of the last 20, 30, 40 years says don't do that. If it's at 2, you can't change the dial up. In other words, and that's, so if sort of like the good faith analysis, I think is very dominant here, where contract law started going down this route, and then it was stopped very deliberately of, no, you can't just build in duties through the tools of good faith. And I know Jay is next and has written about this quite extensively. So that's why I think it's in contrast to contract law. The more contract law takes the shape of plain language, 4 corners, limited sort of extrinsic duties, the more different the insurance law is. Now I'll say, right, and I'm not an expert, but I know a little bit about, like, if we were in Europe or Israel, I have a little bit of familiarity where their contract law is less absolutist and 4 cornersy than ours is. So then the gap between insurance and contract isn't quite as stark. But part of what this paper is about is the difference in both rhetoric and substance between how we treat our contract law and how we treat our insurance law, even though insurance is fundamentally a contract.
Okay. Great. Jay?
So I want to ask a clarifying question and then a substantive question that follows. The clarifying question, I heard the presentation for the first sort of 2/3 or so as largely descriptive. If we look at cases in which the courts apply relatively formal notions, relatively less formal notions, we can break them down into the breadth and depth categories. And then when you came to contra profferentum, you said, yeah, there's some of that, but there's also a better way of treating contra profferentum cases going forward. That is, it becomes normative at that point. When we're dealing with coverage issues, we ought to deal broad, we ought to be more formal because of the breadth issue. When we're dealing with other issues, once coverage has been established, then we can play around the edges a little bit because less at stake. If that's right, then I wonder if at the first level, there's any distinctions to be drawn among classes of contracts. That is, personal lines different than sophisticated commercial parties and so forth, or other categories we might draw. Or is it contract law flat out, and then devil take the hindmost?
Okay, so I let me respond now. I think what I think here. So you're right that this is largely descriptive, and the truth is, I'm happy to leave it as a descriptive project, but I do think, sort of having read enough of the literature, including stuff you've written on the kind of morass of this contra preferentum, I sort of wondered, well, and this, and Dan Schwartz kind of says this idea in his own way, like, isn't some of this sort of thinking useful here too? Though I'd be the first to say it's not going to solve every case, and it's not going to, resolve all the problems. So that's sort of on that. Now, I want to fully understand sort of like when you went back, should there be a distinction between lines? Sort of, I think, which is sort of general question about, should there be a sophisticated policyholder exception, or said the other way, unsophisticated policyholder exception? Should we have a kind of uniform insurance law? There's ways that I'm quite attracted to that idea. It seems like there's not a lot of good case law support for it when you come down to it. You certainly, some things seem to me pretty obvious, right? Like the recoupment rule, right? It would seem to be that, like, I don't know why, large commercial insureds should not have to pay for the defense of their claims that are patently uncovered. That just seems an obvious place where you might want to kind of distinguish between those. A lot of those sort of independent counsel sort of things, like when the insured has their own sort of personal counsel associated with the defense, to me, like, some of those things seem to me pretty obvious places to change. When you get into sort of the scope of coverage, it becomes hard because, as you know, there's a way in which once the court decides what it means, it kind of means that for everything. And then to start splicing and dicing, well, it meant that here only because we applied, that gets messy pretty quickly. So I don't know if this is exactly what you're asking. I'm happy to if you want to clarify the question, to give it another go.
Jay says thumbs up, so I guess that means he's cool with that. Walter, please. Walter, you're muted.
I can't hear. We can't hear you yet.
Right? Yes.
Now we can.
Peter's always surprised when we're still muted because we don't act fast enough to hit the unmute button unless we're just sick. But we're not. We just don't hit the unmute button fast enough. I read your article, and you really, and it's when you don't regularly read law review articles, like, looking at those footnotes is not easy, but they're good. And one of the things I thought about was we're saying, why is insurance contracts different than other contracts? And really, the thing I think about it from sort of the practicing approach that I've had is that the insurance department is a party to all this. It's not just the insured and the insurance company. We look at a class I teach it, when do you have life insurance in place? What's an offer and acceptance? My students are surprised that I'm going all the way back to offer and acceptance, but who prescribes the offer? Is it the application, which is a prescribed document by the insurance department? So they're not a party to the contract, but they're hovering over the contract, is the way I like to think about it. And I think that, I tell my students, I'm not going to use Latin except for ab initio. You're allowed to use that, but now I have to go back and remind myself much more. I knew contracts can be ambiguous and you can then get a different interpretation, but I'm working on contra proferentum and I might even pronounce it right. I think to think about the insurance department is in the mix, and it makes a change in how these are done. But your article points out well that much of this is case law. There's the regulation, which you're not talking about. You're talking about the case law, and there's nice cases interesting cases that I have my students look at to see what is an offer, what is an acceptance, so you have a life insurance policy in effect. at the time of death. And the other, this is just an example of where the contract almost goes out the door. Under a life insurance contract, you have to have proof of death in order to make a claim and get the proceeds. But the insurance departments have weighed in, regardless of what's in the contract, and said, if the insurance company has a reason to know that there's been a death because they stopped paying annuity payments, then they have a different duty to, and it's sort of completely extra contractual.
Yeah, Walter. So thanks for that. And Peter and I and Travis were talking about this a little bit before. So I think what you bring up something I think important and interesting. And one is that, so at least from a kind of theoretical level, when this is coming from the insurance department's regulations, like in the example you gave, then it causes no conflict with contract law because many contracts are subject to regulations, that emanate from the state or federal agency that do what they do, right? So, mortgage contracts have rules and lending contracts have rules. And so in that sense, it matters practically, but not theoretically, because you can always have a regulatory overlay over a contract, no matter how plain language you're going to be, because no one's saying that's coming from the contract. But as you noted, I can't promise you that every case cited in the footnote does not say the word regulator, but most of them certainly don't. Yeah. And that when it comes to these sort of structure of coverage questions, these are not, at least in the justificatory structure of the judicial opinion, related back to regulations. They're not pointing to regulations. They're not talking about the regulator. They see themselves as doing contract interpretation. And that's where the kind of cleavage between the two discourses sort of comes up, and sort of what I'm trying to address here.
Yeah, thank you.
Can I just ask a follow-up to that quickly? Why should that be true? Especially because one party is going to gain something. One or the other party will always gain something by saying, well, you have to interpret this in light of the regulations so it should be in the briefs, and then but it's not, or courts are ignoring what's in the briefs, or like, why doesn't somebody want to make use of that analytic technique for parsing the ambiguity?
So there are probably others on the call that might know more and better than I do. I think that for a lot of these things, I'm not sure. I mean, there is, the statute about the sort of, the bad faith in the liability context about, about paying claims and things like that, and sort of the settlement duties. I looked, a lot of states interpreted it as that there's no private right of action stemming out of there. It's sort of one way around it. But it is certainly not the driving factor as to why it might be that some of these are not covered by regulations. Like, I'm not sure the make whole rule is related to regulation. I don't think they do. The structure of the duty to defend or reservation of rights practice is really a thing that regulators talk much about. So that would be my guess. I could be wrong. Again, I do know the statute. I do know it's a sort of uniform statute that has sort of modifications that has to do with settlement practices. It does get cited somewhat, but I think many states have interpreted that as not creating a private right of action. I assume others here may know more here and can jump in. I could say descriptively, though, you do not see a ton of this, though, of course, there's some of it.
Great. So it's now 5 o'clock, and that means that anybody who wants to go can just vanish electronically. Thank you all for coming. Thanks for a great semester. Chaim, would you be willing to stick around? Because there's 2 more people at least in the queue.
Absolutely.
Great. Okay. So Jake, you're next. Everybody else, have a great break. See you next semester. Jake.
Thanks a lot. Can you hear me?
Yep.
Yes.
Great. In light of the public's reaction yesterday to this everybody knows what I'm talking about. Is this the existence of this debate? Does it stem from marketplace behavior of insurers? Like, if they acted maybe a little more appropriately, were more just in their distributions, would this be less of an issue? Like, particularly for me, in health insurance is one thing for sure, but and asymmetries you've talked about before as well. But my home insurance, I don't get the policy until after I paid for it, right? And just as a sales tactic, I have plenty of reason to say that I should be afforded some some leverage just based on the fact that I wasn't even able to see what the product was that I was buying. So I'm wondering, is there a place for market behavior as a way to sort of limit the scope of this discussion? Like, would this discussion be necessary if they acted more just in the first instance?
So, Jay is the author of a book on this topic. So I guess a little bit depends on what you mean by market behavior. In other words, courts, and this a little bit goes back to the discussion with, I think, Travis on the restatement of consumer contracts. So there too, you're often not getting the terms until after there's been a contract, or at least you've gone some way down, right? That I think you're right that started in insurance. I don't think it ended in insurance. And then to some degree, you could make the opposite argument, is because your homeowner's policy is essentially standardized. You can look up what State Farm's model policy is, and that's the one you're going to get, plus minus an endorsement or two, state specific, or if you buy, right? So in other words, that does sort of cut both ways. I think if you ask why is insurance regulated, one could ask why is, and this is a little bit to Walter's questions, or why is insurance regulated through these departments where other things are not, right? So I think that has to do with, there's a long history to that, but the fact that you're giving them money today and hoping they'll show up tomorrow. Usually you won't be calling on them, right? In most cases, right? A good life is one where you've bought lots of insurance and never called an insurance agent. So it has a sort of imbalance, I think, exists to some degree in other industries, but not to that end, right? Which is driving that. So again, I think what you're saying is what I would call the roots of the counter contract narrative, right? If you look through all those cases, there's a battery of justifications that they come back to, including the asymmetries, including the idea, particularly in personal lines, that this shows up like disability insurance. Where now that I'm disabled, I bought insurance to shelter me from the harms of disability, and now that I'm disabled, on my to-do list is fighting with the insurance company, right? And therefore, that's often the justification for a bad faith claim in the first party context. So I think that's right, but I guess what I'm trying to struggle with in this paper is, then if that were always true, then we wouldn't have all this rhetoric about it's just a contract, and not just rhetoric, all this doctrine that sort of solidifies it's just a contract. So I'm trying to understand sort of, how do these two things live together? Is it just noise, meaning every time an insurer wins, it's the court throws just contract language at just a contract language at you. Every time the insured wins, it's a particularly just contract. So I think there's a little bit more pattern here and a little bit more coherence. So I don't want to overplay and overstress the coherence.
Okay, I think Barbara Richardson's going to get the last question. Barbara, the floor is yours, or the E floor, whatever you call it.
Thanks, I appreciate it. So I love the conversation, and so it turns out that I'm a regulator. So
Okay.
So I'm coming from the other perspective, and I would say that the one thing that I think is important to really think about is the commercial versus the personal line issue, because you're going to get courts taking very distinct views on the same topic and altering their belief system based on whether this is a personal lines or a commercial line process, much like the regulators do. And because the control over the commercial products is such a light touch from the regulator world, you would never go back to the regulations. You just don't go make that move back. So I was just curious whether or not you linked any of those back to the product lines, or even just broken it down by personal and commercial.
So in the paper, I don't. And I guess one question I have for you, because we were asking before what the regulator's perspective is, but if you think of the structure of the duty to defend, so obviously, this shows up in the auto context, in the home context, and then of course in commercial context. So obviously, what the cases stress on is just the whole structure is really, really different if the insured has assets beyond insurance or not, right? That certainly matters. And recoupment issues. But the way I've seen the sort of normative construction of what is or is not included in the duty to defend, I haven't seen courts saying, well, because this is a personal line, we're going to do this. Whereas this is a commercial line, we're going to interpret it more broadly. I think there might be, as I said, I think in something like recoupment, there's a very good case for that. But you know, the case law doesn't, so far as I can tell, doesn't really talk that way. So you know, and Barbara, you know, so happy for you to weigh in on some of the regulatory questions. I'd be interested to know your answer. Some of the regulatory issue, yes, but so they're clearly different, and certainly the regulatory structure. Now, you could make an argument that and I'd say this maybe I'll end with this with the status points. You can make an argument that the reason insurers do not try to contract around various, I would call structural duties of like the make whole rule or the duty to defend or how they structure reservation of rights practice is because if they do that, they think they're maybe afraid that the regulator might slap them down. I don't know. That argument is made. It's possible, but I don't know if it's true.
And usually, it depends on the particular situation. So, I mean, I'm not sure if I would think that was a valid argument from the insurance companies as a regulator. I just don't think it is. But I would say that the duty to defend from a regulator perspective really has to do with this. It's the companies defending their own rights, not the consumer's rights. They never care what the consumer wants or needs when they're making their defense. Their defense is all about whether or not they have to pay the claim. So it's still their money they're defending.
Absolutely.
Well, okay. A sign of a great talk is that it's gone over and there's lots of questions. I don't see any more though, so maybe it's time to bring this to an end and just thank Chaim again for showing up with such a great paper.
So much. Appreciate it.
All right. Bye, everybody. See you next semester.